Appeal is for office item 1, second appeal 78 of 1999.
The order was uploaded yesterday. The order was uploaded yesterday.
Yes. With regard to Your Lordship, the substantial question of law A framed yesterday by Para Pati, Your Lordship may kindly pray that Your Lordship may kindly take up the oral evidences of only 2 witnesses are. And both are defendant witnesses.
Their DW.
Yes, defendant number, defendant witness number 9 and 11. Ramanand Prasad Saur and Asarfi, who is the
Brother and the
yes,
one is the brother,
and the husband.
other is the husband.
Yes. Why their evidence is important? Your Lordship would find absolutely contradictory with regard to the receipts granted by the vendor, defendant number, and I'll place it.
The fact that the receipts were granted later on is not in dispute.
Later on, but Your Lordship, entire question is related to bona fide.
Yes.
So if bona fide I'll show it is not bona fide, why it is not bona fide I'll show. That is the reason I am placing the
I
evidences
want
of.
to know trajectory of your argument in the sense that when you say that it is not bona fide, it is as we could see yesterday, that your case for lack of bona fide could at best be stated on the ground that the payments were made subsequently after coming into the knowledge of the fact that there is already an agreement for sale.
I'll also
Apart
show
from something
that
else.
no payment itself is not proved. Therefore, I'll say.
We will
If-
not enter into that. Please don't. We don't. There is already a finding. That finding we are not going to touch.
I'll-
Please don't. There is already a finding. Now you are trying to enter into a point that the payment
No,
itself is not.
Why
proved.
I say that whole point again would come to bona fide.
No. You see, we have not opened the question of law to such an extent that the bona fide is to be tested on the ground as to whether the payment was proved or not.
Payment, let us assume that payment was
Yes,
proved.
we have recorded
Then-
it yesterday that the payment stood proved. So by 4 documents, B1 to B4, and the date of payment has been mentioned. In one, with respect to one sale deed, payment was made after filing of the written statement in this case, and with respect to the other sale deed, the payment were also made after filing of the written statement in the previous suit. So the dates of payment, we will not.
But DW9 says the payments were made to different sons,
We will not bother.
and the DW11 says that all payments
Please,
were made to.
Do
So
not,
absolutely
we
contrary.
are not inclined to open this Pandora box. Yesterday, this fact was recorded in presence of both of you that these were the dates of payment as recorded by both the courts.
Yes.
The learned first appellate court has said that this payment, even if later on, has got no relevance because the sale stood concluded. That is the finding of the learned first appellate court. Now, this is the question of law as to whether the payment made subsequently, in spite of having knowledge that there is a previous agreement, can that bona fide be tested on that? Please confine to that.
there are altogether 5 times the payments have been made, and each of the 5 payments that were made, it has been said that 1 room, 2 room was given possession. So with each payment, possession of 1 room was given. There are altogether 11 rooms in the complete building, and then with each payment, therefore, the defendant number 2 and 3, who are the purchasers, they have been put in possession with different portions of the property 5 times. This is one. And with regard to each payment. But your Lordship may kindly turn to the sale deed itself. Sale deed says that I am putting in possession. Whereas they, according to their own statement, they were not put in possession, they were put in possession after 25 days of the execution of the sale deed, and thereafter with each payment they were put in possession. So here, your Lordship may see Sarfi Lal's house evidence.
Mr. Gupta, please don't interrupt this. 2 things are very clear. Firstly, that you were not put in possession. Right? You were not in possession of any portion of this property. Secondly, the vendor was in possession of some portion of the sold property. Some portion or whatever. Now the vendor this fact has also come that at different point of time the possession was handed over. Merely because the handing over of the possession has been mentioned in the suit, in the deed, that will not take you anywhere so far as the substantial question of law is concerned.
Because the whole question again
We are not
bonafide.
testing the substantial question of law has not been thrown open to test the bona fide on the ground of possession. There are various parameters to test the possession, right? One was the initial substantial question of law, right? Previous knowledge. The second was payment of consideration. There could be a third, fourth. There may be n number of elements to test the bona fide in a case. But we have confined it to 2 points on referring to previous knowledge and deferred payment of consideration as to whether this deferred payment of consideration has any bearing in it. You have anything on that, or
Yes.
you are on a shaky
No.
wicket of this?
I have. Your
If you
Lordship,
have, you just argue. If you don't have, you just tell us.
No.
You just confine it to that. Yesterday you were referring to some judgment, Madras High Court. Who was referring to Madras High Court?
Yes.
तो आप लोग का आपस में communication नहीं है क्या? What is this?
एक लास्ट हम एविडेंस दिखा दे रहे हैं, उसके बाद
किसका evidence?
हम ये सरफी लाल साहब.
DW11.
हाँ.
क्या बोलना चाहते हैं आपसे? What do you want to say?
Para 73, what he says is, वो हमसे पढ़ दे रहे हैं, उसके बाद I'll close. हाँ, केवाला लिखाने के समय जो रुपया दिया वह रजिस्ट्रार के सामने दिया गया था। केवाला के बाद 5 बार जो रुपया दिया उसमें पहली बार छोड़कर बाकी चारों बार मुकदमा के बारे में चर्चा किया। Therefore, he had the knowledge about the agreement, and once he had the knowledge about the agreement and he was discussing any payment made thereafter cannot be termed as bond. This is my side. It would not fall within the provision.
This submission is not established by referring to the written statement in the previous suit and the written statement in the present suit. It is fully established by that.
No, it conclusively proves this fact because these two things, at least when they are relying on a sale deed, when they are relying on the sale deed and that sale deed and undisputed fact itself goes to show that all these payments were made subsequent thereto and they were clear about the
Mr.
pendency
Gupta,
of
there
this.
is no doubt on this. Once a payment is made after the filing of written statement in this suit, there cannot be no doubt that somebody is claiming through a registered
No,
through an
but few
agreement.
payments have been made even prior to this
So
agreement.
that is, for that you have the previous written statement.
Yes,
For that you have the previous written statement.
yes, that is. But this admission conclusively proves his own admission that four
DW11,
payments,
okay. Para
Four payment.
73, all the 5 payments.
all the 5 payments except the first one, he says, rest 4 whenever they were paid, the case was discussed.
The case or the agreement? Para 73.
73. Case was, the pending case was discussed. This is what he says.
Just a moment, let me just lay my hands on this. Deposition of DW. Para 73, right?
Case was discussed, not the agreement. केवाला के बाद 5 बार जो रुपया दिया उसमें पहली बार छोड़कर बाकी चारों बार मुकदमा के बारे में चर्चा की।
The learned counsel for the appellant, by referring to the substantial question of law framed yesterday, the first substantial question of law framed yesterday has referred to the evidence of DW11 and has submitted that during his cross-examination at paragraph 73, he has stated that after the registration of the 2 deeds, and after the registration of the deed, the payment was made 5 times, and except the first payment, the remaining at the time of making payment on 4 occasions, there was a discussion in connection with the litigation. Okay? The learned counsel, by referring to this, has submitted that the DW11, who is the purchaser of the property himself, namely Ashrafi Lal Sao, has himself admitted that the part payments were made after having knowledge of the pending litigation. अच्छा, उनकी वाइफ का एग्जामिनेशन हुआ है.
नहीं.
He has submitted that the DW3 has not the defendant number 3 has not been examined in this case, although the 5 payments relate to both defendant number 2 and defendant number 3. ठीक है, अब आप सीधे लॉ पे आए.
हाँ. और सेकंड योर लॉर्डशिप. अच्छा.
वो
दूसरा problem.
वो बोनाफाइड मतलब वो जो नेक्स्ट है इनके इंस्टेंस में जो बना है वो बाद में, पहले इस पॉइंट को कंप्लीट करें.
ठीक. Better होगा because my learned friend has searched for that
हाँ,
cross
yes,
court judgment.
भाई आप लोग का साझा केस है ना, जिसको मर्जी प्लेस करें.
नहीं.
आपस में कम्युनिकेशन रखिए, आपस में कॉन्फ्लिक्ट मत रखिए.
नहीं कॉन्फ्लिक्ट नहीं. ये मेहनत किया है, इसी के लिए हम बोल रहे थे कि ये हम और सर असिस्ट करेंगे.
मेहनत तो बहुत किया है मुझसे. चलिए,
ये यही प्लेस करेंगे.
अब ये एमआईकेस के लायक हो गया इस मेहनत से.
नहीं किया है.
दिस इज हाउ आई जज द जूनियर काउंसिल कि
के लिए.
किसको हमको एमआईकेस अपॉइंट करना है. एक केस में मेहनत दिखा देते हैं तो हम दूसरा केस में उनका एमआईकेस अपॉइंट कर देते हैं.
I intend to argue on the point that under section 19B of the Specific Relief Act.
सर आप थोड़ा साइड में बैठिए ना, इनको असिस्ट नहीं करने का. इनको असिस्ट नहीं करने का, आप थोड़ा साइड में बैठिए.
उधर बैठ.
हाँ, यस प्लीज गिव मी दैट जजमेंट.
It pertains to the old act prior to 63 amendment. So the section 19B is pari material to section 27B therein.
Is it quoted here?
No, that is not quoted. I can only, it emerges from the title of the act, the Specific Relief Act 1963, 47 of 63. The case is registered therein as AS number 100 of
ये
63.
पुराना वाला एक्ट का क्या नाम, क्या ईयर था? स्पेसिफिक रिलीफ एक्ट पुराना, स्पेसिफिक.
I'll just check and
ये स्पेसिफिक रिलीफ एक्ट 1877. Let's a good years compare. 1877. हाँ बताइए. Let us see.
That section 27 reads, subject to correction and print, except as otherwise provided by this chapter, specific performance of the contract may be enforced against A. Either party thereto, B. Any other person claiming under him by a title arising subsequently to the contract, except a transferee for value who has paid his money in good faith and without notice of the original contract.
The word who has paid his money in section 27B of the Specific Relief Act means a person who has paid the whole of the consideration,
That is
and not a transferee who has paid only part of it.
in this regard.
Just ऐसे आधा थोड़ा और जजमेंट को पढ़िए इसको. फैक्ट पढ़िए. Exhibit A, dated 19th March 1960.
The first defendant The first defendant resisted the suit on the ground
नहीं इसको पढ़िए, उसके ऊपर से पढ़िए. Exhibit A dated 19th of March
1960
executed by first.
by the first defendant for a price of 1,000. On 9th March 1961, the first defendant sold the property to second defendant for a swap of rupees perhaps 19. Notices passed between the parties in which the plaintiff's claim was denied, and the plaintiff filed the present suit for specific performance of agreement Exhibit A1. The first defendant resisted the suit on the ground inter alia that the agreement of sale is vague, that there was no consensus ad idem between the parties as to the exact extent to be sold, that subsequent to the agreement of sale, the plaintiff gave up his rights, and that only to the arrangement of sale, the plaintiff gave up his right, and that only thereafter the property was sold to the second defendant. The latter, while adopting the plea suited by the first defendant, raised the further plea that he is a bona fide purchaser for a value and in good faith without knowledge of the prior agreement of sale. The trial court negated all the contentions of the defendants and decreed the suit as paid for. But on appeal, the lower appellate court, on a process of reasoning wholly and unintelligible and perverse in the extreme, reversed the decision of the trial court and dismissed the plaintiff's suit. The judgment of learned subordinate judge betrays utter lack of grasp of elementary principles of law of contract and specific performance. The plaintiff's agreement of sale provides that out of the total consideration of rupees 1,000, an advance of 100 was paid, that within 2 weeks from the date of agreement, the sale transaction should be completed, and that in the case of vendor committed default, he should return the sum of rupees 100 advance paid and also pay the vendee a further sum of rupees 200. The ease of plaintiff as set out in the prior notices which passed between the parties in the plaint and as is spoken to the oral evidence is that he always ready to complete the transaction, saving purchased stamp papers, that when he pursued the first defendant, she latter was evading. The lower appellate court dismissed the plaintiff's suit on the following grounds: 1. That there has been an abandonment and waiver on the part of the plaintiff. 2. The contract is vague and uncertain and cannot be specifically enforced. And 3. That the second defendant is a transferee for value who has paid his money in good faith and without notice of plaintiff's agreement. So the plaintiff cannot in any way claim any rights as against the second defendant. Before I proceed further, it is necessary to refer Exhibit A2, the notice issued on behalf of the plaintiff dated 7th July 1960, and the reply sent on behalf of the first defendant, Exhibit A3, dated 25th July 1960. Exhibit A2 is a simple notice sent by plaintiff expressing readiness and willingness on his part to complete the transaction and charging the first defendant with evasive conduct. In the reply notice, Exhibit A3 was stated that the first defendant was throughout willing to complete the transaction as per the contract. But the plaintiff held the first defendant on 3rd April 1960 that the former had some inconvenience in purchasing the property, that the first defendant therefore was at purchasing the liberty to sell the property to any third
You
party.
can come to first, fourth paragraph, fourth page. It is significant. It is this significant
answer,
using the words.
Using the word to avoid competition, the second defendant has blurted out the truth that he was purchasing the property hastily in competition, which is in context meant competition with the plaintiff. In this background of gross negligence and total absence of any inquiry whatsoever, it passes of one's comprehension how the learned subordinate judge held that the second defendant is a bona fide transferee in good faith within the meaning of section 27B of the specific relief. But I am permitted to take a pause and try to bring to the notice of this honorable court that the same thing has been done by Ashrafila. He has deliberately concealed the fact that he has entered into a registered sale deed. He has specifically directed his wife not to reveal this. Now, also there is a statement made by him in the deposition. That मैं अपनी डिफेंडेंट नंबर मुद्दाले नंबर 3 का गवाही नहीं करवाऊंगा. So that raises a great deal of suspicion on the part of the bona fide of the Shafilal is concerned. So good faith is under a heavy scrutiny hearing, in my humble submission. Further, out of the total consideration of rupees 1900, the sale deed recites that rupees 240 was paid to the first defendant on the date of the sale deed, and for a sum of rupees 400, the second defendant simply executed a promissory note in favor of first defendant. We are not concerned with the other items for consideration. The sale deed was executed on 9th March 1961, but was registered on 21st March 1961. The first defendant has admitted in his evidence that the cash of rupees 240 was paid to him, not on the date of sale, but only on the date of registration. But before the notice has been issued on behalf of plaintiff on 17th March 1961 to both the defendants, with the result that the cash of rupees 240 was paid to the vendor only after second defendant obtained the plaintiff's lawyer's notice. Our notice is dated 27th of June 1980. This aspect is pointedly referred in the judgment of the trial court. The learned subordinate judge gets over this on the ground that when the sale deed recites that cash was paid on the date of execution of the sale, this story cannot be accepted. He has overlooked that both the defendants are making common call and that second defendant was examined after the first defendant. There was no cross-examination of the first defendant, nor did the second defendant in his evidence say that the cash was paid on the date of the sale. A perusal of the reasoning of the lower appellate court shows that the learned subordinate judge is of the view that the face of the recital in the sale deed, any evidence that the money was actually paid on the later date, would be inadmissible. From start to finish, every step in his reasoning is wrong. When he reversed the judgment of the trial court, it was his obvious duty to have considered the findings of the learned district magistrate, who has adverted to all these aspects. On the admitted facts, it has to be held that cash of rupees 240 was paid after the defendant received the notice issued on behalf of the plaintiff. When the second defendant did not pay the entire consideration and passed a promissory note of rupees 400, it is settled law that he cannot claim to be a transferee who has paid his money within the meaning of section 27B of the Specific Relief Act. In a recent bench judgment reported in so and so, of which I was a member, this identical point came up for discussion and on consideration of the entire case law. It was held that a transferee, the claim, the protection under section 27B of the Specific Relief Act must have paid the entire consideration, and if for any portion of the price a security alone had been executed, the transferee cannot claim to be a transferee who has paid his money. This principle was laid down in the leading decision in Himmatlal Motilal versus Vasudev Ganesh, and it has been uniformly followed in all the courts. In every
27B in the earlier act is identical to the present. We have got the act also. एकदम same है. Do you want to see respondent? You can just have a look. दिखाइए.
हम दे
देख लीजिए. Just ये act का copy दिया 77. दिया. Correct? Identical? चलिए ठीक है. आपका सेल डीड कौन सा एग्जिबिट है? एग्जिबिट ए. यहाँ से निकालना बड़ा मुश्किल होगा हमारे लिए. है कॉपी है? तो दीजिए. Because this छूने से ही फट जा रहा है. So I'm just finding it very difficult to handle.
Provide the certified copies. You have obtained from this honorable court.
दिखाइए सर.
It took 6 months for you to obtain. But then I was not in the case. They were involved.
And this is the second sale deed of Chandrakanta.
ठीक. इन दोनों को ना फोटो कॉपी करवा के मंगाइए इनको वापस ठीक है हम देख लेंगे
Only one thing more which I want to indicate, that the possession was not transferred at the time of execution and registration of the seal deed, which is evident from the first print.
I have told you इतना देर तक आप यहीं पर हैं पोजीशन पर हम लोग नहीं जा सकते हमारा जो सब्सटेंशियल क्वेश्चन ऑफ लॉ है आप बस उतना ही पर करना है
उसमें दिखा बोनाफाइडी दिखा था lack of
नहीं नहीं
bona fide
आपका कहाँ हम बोले हैं कि लैक ऑफ बोनाफाइडी पर आपका पूरा एवरी पॉइंट इज ओपन ओनली 2 points of lack of bona fide knowledge of previous agreement and deferred payment payment after having knowledge that there is an agreement
that really emerges from the seal deed itself.
सेल डीड में तो खाली लिखा है deferred payment
Deferred payment but 10,000 अभी नहीं है
10,000 का जो और बताइए
and so far issue of non framing of the
नॉन फ्रेमिंग पर नहीं है हम लोग तो सीधे वो कौन सा
readiness and willingness के
Readiness.
point. तो
इस
उस
पे क्या?
issue पर
एक सेकंड The learned counsel for the appellant has relied upon the judgment passed by Honorable Madras High Court reported in 1968 SCC Online Madras 134 and has submitted that identical provision was available under section 27 within bracket B of the Specific Relief Act 1877 as that of section 19B of the Specific Relief Act 1963. He has submitted that in the said judgment it has been held that payment of the term inverted comma who has paid his money inverted comma close means the inverted comma the whole of the consideration inverted comma close.
One judgment only, one good faith, only 4 lines are this nothing.
It's a nickel.
Although this was a case where the person was in part possession of the property, but what would be good faith? It has been discussed in para 14. Section 19 quoted. 2006 SCC 40.
आप पढ़िए please.
Only para 14 are read.
Yes.
After quoting section 19, it says, as can be seen from section 19A and B extracted above, specific performance of contract can be enforced against either party thereto and B against any person claiming by him by a title arising subsequent to the contract, except a transferee for value who has paid his money in good faith and without notice of the original contract. Section 19B protects the bona fide purchaser in good faith for value without notice of the original contract. This protection is in the nature of exception to the general rule. Hence, the onus of proof of good faith is on the person who takes the plea that he is an innocent purchaser. Good faith is a question of fact to be considered. So here my submission would be, as my learned friend already submitted, that the moment good faith and the amount also has to be for value is there.
15 भी पढ़िए please.
For value is there.
Kindly read 15 also.
Yes. Notice is defined in, because your lordship was not going into this question, but my submission would be.
Kindly read it.
I'll read it. But here is a question where he is in part possession, but a purchaser is required to make an inquiry. That is my submission. Notice is defined in section 3 of the Transfer of Property Act. It may be actual where a party has actual knowledge of the fact or constructive. A person is said to have notice of a fact when he actually knows that fact or when, but for willful abstention from an inquiry or search which he ought to have made or gross negligence, he would have known it. Explanation 2 of section 3 reads as explanation 2. Any person acquiring any immovable property or any share or interest in such property shall be deemed to have notice of the title, if any, of the person who is for the time being in actual possession of thereof. Section 3 was amended by the Amendment Act of 1929 in relation to definition of notice. The definition has been amended and supplemented by 3 explanations which settle the law in several matters of great importance. For the immediate purpose, explanation 2 is relevant. It states that actual possession is a notice of the title of the person in possession. Prior to the amendment, there has been some uncertainty because of divergent views expressed by various high courts in relation to actual possession as notice of title. A person may enter the property in one capacity having a kind of interest, but subsequently, while continuing possession of his property in capacity or interest may change. A person entering the property as a tenant may later become usufructuary mortgagee or may be an agreement holder to purchase the same property, or he may.
That's right. It's okay.
So-
That portion would be relevant, I think.
So I'm only placing, your lordship, first few lines of para 15.
That's
First few lines says that, your lordship, notice is defined so and so. A person is said to have notice of a fact when he actually knows that fact or when, but for willful abstention from inquiry or search, which he ought or have made, or gross negligence, he would have known it. So here is a case where the defendant himself said that I did not make any inquiry.
Yes. That finding is there. He did not
Yes,
make any
yes.
inquiry. Which was the inquiry which would have revealed this fact?
Yes, and
What was the
Yes,
inquiry? What
that
you
there
see,
was a prior
registry.
agreement.
No, there was a prior agreement, but prior agreement is not available in public domain. One can go and get a non-encumbrance certificate if there is a registered deed.
Yes.
But agreement is not registered. So it is between two private parties. How will he get this notice from
Yes, yes.
prior agreement?
He does not even ask. He vendor, he himself says that I did not make any inquiry whatsoever. Once he says, then these 3 lines they come into play. What it says, I'm repeating one line here, Lordship. These paragraph 15, only 3 lines here, Lordship.
Will not open it to the
It says that but for willful abstention. if he, from
As
an
a
inquiry
question
or
of law
search
नहीं
which he
करना।
ought to have made and
ना,
done.
पूरा का पूरा
पूरा नहीं
bonafide
हम बोल रहे हैं, ये तो क्वेश्चन है, ये तो क्वेश्चन फॉर्मुलेट हुआ ही है कंस्ट्रक्टिव नोटिस का. तो कंस्ट्रक्टिव नोटिस if he would have made an inquiry
then it would
and he does not make an inquiry,
does
then
he does it say that he did not make any inquiry or he did not make any inquiry from the vendor? What is it?
he says that he did not make any inquiry.
Any.
And last only submission he has stated in his, therefore that portion, if your lordship would allow me to read that portion of the evidence of circular.
Yes, what is it?
It
So far
says
as
that,
so far as constructive notice is concerned, we can have a look at that.
so constructive notice, your lordship, if he would have made an inquiry and he abstains from making any inquiry, then he has the knowledge of the,
No inquiry and abstains from making any.
yes, and the word is but for willful abstention from inquiry or search which you ought to have made or gross negligence, he would have known it. So these are the words. And the possession is only an additional fact where if a person is in possession, it is deemed that you are have not. But let us assume that I am not in possession. Then also if he does not make any inquiry, then for his gross negligence and abstention from inquiry, he would have known it, and he does not make any inquiry, then that is that would cover that a person has the notice.
The learned counsel for the appellant on the point of constructive inquiry as constructive notice has submitted that the defendant number 3 has not been examined, and so far as defendant number 2 is concerned, he did not make any inquiry. Such finding has been recorded by the learned courts. The learned counsel has further submitted that the act of abstaining from making any inquiry the learned counsel has also submitted that a person is said to have notice of a fact when he actually knows that fact or when, comma, but for willful abstention from an inquiry or search which he ought to have made or gross negligence, he would have known it. For this proposition, the learned counsel has relied upon the judgment passed by the Honorable Supreme Court reported in bracket 2006 bracket close 6 SCC 402 para 15. He has emphasized on the initial few lines of the aforesaid paragraph, which deals with the proposition of law. The learned counsel has also relied upon, this is coupled with the fact he was making that submission. I'm recording it. The learned counsel has also submitted that the aforesaid situation is coupled with the fact that the defendant number 2 and 3, that the defendant number 2 had asked defendant number 3 not to disclose about the purchase of the property to anybody. The learned counsel has submitted that in case of constructive notice, the conduct of the parties is primarily to be seen to come to a conclusion.
Yes. Then in this judgment itself, para 18 your lordship may see. Para 18, the Honorable Court refers to an earlier judgment of the Honorable Supreme Court, and I am not reading the first few lines. Your lordship may see the words after 10 lines. Secondly, Therefore, the conduct is important. The secondly, the haste with which the sale deed in favor of the appellant was executed was unusual. It is more usual for an agreement to be executed in such cases rather than arrive at an oral agreement on one day and to have the sale deed executed the next day and registered the following day. For some reason, the appellants were in hurry to get the deed registered. What was the reason? In view of all the circumstances, we are inclined to accept the evidence of so-and-so knew the execution of agreement with the plaintiff on March 1, 1960. Therefore, this conduct, as can be seen from the paragraph extracted above, that in case of contradictory evidence, the circumstances have to be kept in view in deciding whose version is more acceptable. One of the circumstances that was held again the subsequent purchaser was that the parties were residents or had shops in the same vicinity, and it was not probable that the subsequent purchaser would not have come to know of the execution of the agreement. In such a case in hand, the trial court as well as the High Court have given reasons based on evidence and have indicated several circumstances for not accepting the version of defendant number 2 to 4, that they have no knowledge of the prior agreement exhibit A3. One of the circumstances being the parties are neighbors in place of the business as well as the residential locality. We have also referred to that briefly. In view of what is stated above, it is clear that defendant number 2 to 5 were not bona fide purchasers for value without notice of the original contract, and they were required to make an inquiry as to the nature and possession or title or further interest, if any, of the plaintiff over the suit property at the time when they entered into sale transaction, notwithstanding that they were already aware that the plaintiff was in possession of the property as a tenant. What is material is inquiry at the time when the subsequent sale transaction was entered.
The learned counsel has also referred to paragraph 18 and 19 of the aforesaid judgment reported in bracket 2006 bracket 06 SCC 402, and has submitted that the manner in which the bona fide is to be tested with respect to inquiry prior to purchase has been fully discussed. He submits that in the said case, the people were in the vicinity and the plaintiff did not make any inquiry with the people around. In the present case, the adjoining property was already purchased by the plaintiff, but the defendant number 2 did not make any inquiry from them. This conduct is also an indicative of the fact that he had purposely omitted to make any inquiry from the plaintiff. Had he made that inquiry, the true fact would have revealed then and there.
The two properties which we acquired, Your Lordship, for that we have produced Exhibit 7, undisputed, the map of the property. They are both the properties which were
It is not in
purchased.
dispute, it is
No,
adjoining.
the land which is in dispute is in the center, and both the properties which were purchased were on the either side of the.
He has also
Therefore-
submitted that considering the nature of the property, the trial court had decreed the suit by observing that the property involved in the present case was the property involved for ingress and outgress with respect to the other properties which were already purchased by the plaintiff by way of registered deed from the same vendor.
Yes. And this property was in the middle of the two properties. This.
The learned counsel has also submitted that since the vendor was this particular property was in the middle of both the properties.
Yes.
Middle or sandwiched by both the properties.
It is, Your Lordship,
Sandwiched by.
Sandwiched by.
It was sandwiched between both the properties
Yes. Purchased.
belonging to the plaintiff,
Yes.
sold by the same vendor
Same.
to the plaintiff. Had the defendant number 2 and 3 made any inquiry from the vendor was duty bound to disclose the fact about the agreement of sale, but having not made any inquiry, his purchase of the property is not bona fide, and therefore there can be no doubt that he had constructive notice with regard to the agreement of sale.
And rather they say, the Sarfi Lal Sahu says, on the contrary, that I did not make any inquiry in registry office so and so. I did not make any inquiry with the neighbors. I did not make any inquiry with the vendor. Only thing which he said, that whatever the son said, I transferred. That is. So therefore he abstained. That is my son.
The learned counsel has submitted that the only inquiry which the defendant number 2 in his evidence has stated is with the son of
Son.
the vendor. Rather, admittedly, he made no inquiry from the vendor.
Well,
That's all.
yes, that's it.
और वो willingness and उस पे
हाँ,
क्या बोलना है?
Readiness.
Readiness and
Your
willingness.
Lordship, first, my first submission again, Your Lordship has already
And no,
recorded.
फिर still you
That
just
para 7, I have made very specific statement with regard to my readiness and willingness, which has been answered by them in para 7.
उनके भी पैरा 7 में ही आंसर है.
हाँ, उन्होंने पैरा 7 में ही आंसर किया है और मेरा पैरा 7 और 8 का आंसर they have answered in para 7 of their written statement, and they were required to controvert this fact. Absolutely no statement with regard to this. So they were required to deny this fact, and if there was no denial, then therefore no issue was framed. Because issue would be framed only when a party asserts and the other party denies that particular fact, then the court would frame an issue.
This is one part.
This is one.
Second is remand पे कुछ बोलना है. Nature of remand.
Nature of
Earlier when it
Yes. Your Lordship, this particular question was never formulated by the appellate court. Only 3 questions formulated, and this was not even an issue, and therefore they did not raise it earlier. Any person who says, now this is absolutely a contract, it is not between two of us. We may waive a particular point. So the defendant, by his conduct, he waives this point of readiness and willingness. He does not raise it. Then at a subsequent stage, he cannot raise it because the court cannot make an inquiry which a party has not raised it.
the learned trial court has recorded a finding that he was ready and willing to do the needful. The appellate court has not given any finding.
No, appellate court says
it is irrelevant.
That's right.
But no finding.
But trial court has given a finding. Trial court has given a finding that once they are ready and willing to perform their part of the contract, there is no reason that the suit should not be decreed. This is the finding I saw in the trial court's judgment.
Yes, it is there in page 20.
Page 29,
It is there in the trial court's judgment.
page 29.
So far as natural justice equity is concerned, it is in favor of plaintiff and not in favor of defendant, because the plaintiff was in possession of north and so and so, situated in the middle of the two. If the defendant number 2 and 3 have obtained a sale deed for the for consideration, and if the defendant are allowed to remain in between block A and B, there will be disturbance and trouble between the plaintiff and defendant number 2 and 3, because block E land is only a passage for entrance to block B land of the plaintiff. When the plaintiff is ready and ready to perform his part of the contract and ready to pay the remaining of the consideration, why he shall be debarred from his right, so and so. Again, relying on Supreme Court, when the plaintiff is ready, willing and ready to perform his part of the contract, there is no obstruction to get the sale deed executed in respect of the agreement.
Which is that judgment which has been relied upon.
Yes, this is 71 Supreme AIR 71 Supreme Court 1238. This is Chandi Lok and Lok and other versus Chuni Lal Sabar. That printout I have not taken.
With respect to the second substantial question of law framed yesterday, the learned counsel for the appellant has submitted that a specific statement was made in paragraph 7 of the plaint on the point of readiness and willingness, which was responded to by the plaintiff in paragraph 7, which is a response to both paragraphs 7 and 8 of the plaint. The learned counsel submits that in the entire suit there was no dispute with regard to readiness and willingness regarding payment of the balance consideration amount by the plaintiff. And since there was no denial with respect to readiness and willingness of the plaintiff, so no specific issue as such was framed. The learned counsel has also submitted that the fresh judgment was passed by the learned ट्रायल कोर्ट ही पास किया था ना फ्रेश जजमेंट किसने पास किया था ट्रायल कोर्ट ने पास किया था was passed by the learned trial court by virtue of an order of remand wherein certain points were already formulated by this court.
Acha, I stand. The appellate court remanded, but your lordship, that order was set aside by the High Court in instance appeal. So the second order again was passed by the appellate court itself, but the original order which I had read was still subsisting.
Just a minute. The learned counsel has submitted that initially the first appellate court had remanded the matter to the learned trial court by directing to decide on certain points, but the same order was set aside by this court in
Miscellaneous appeal
MA number
300 of 1991.
300 of 1991 within bracket R, wide judgment dated 21/1/1992. learned ये ऑर्डर हमारे पास है, मंगा लिए थे.
अच्छा ठीक है, वो मेरे पास नहीं है, कल ही नोट किया था.
इसी ऑर्डर से लिखा है. The learned counsel has referred to the order passed in MA number 300 of 1991 within bracket R, wherein this court observed that it was clear that Rule 23 or Rule 23A of Order 41 was not applicable. इसका क्या relevance है? 23 भी नहीं applicable है, 23A is also not applicable. The court provides, इसको quote कर देंगे, para 4 quote कर देंगे. He has submitted that this court directed the learned first appellate court to proceed to dispose of the lists on merits as provided under Rule 24 or of Order 41
Yes.
on the basis of whatever material available.
Materials were there.
The learned counsel has submitted that. Consequently, the order of remand was set aside and the matter was remanded to the First Appellate Court with a direction to dispose of the appeal on merits on the basis of evidence already on record after giving opportunities. The Learned Counsel has submitted that the Learned First Appellate Court upon setting aside the order of remand has passed the impugned judgment and has refrained itself to go into the point of readiness and willingness by observing that the suit property was already transferred. Yahi hai na? He has also submitted that the Learned Trial Court had given a clear finding with respect to readiness and willingness, inasmuch as the Learned Trial Court, while decreeing the suit, also observed that when the plaintiff was ready to perform his part of the contract, there was no reason that the suit for this specific performance be not decreed in his favor. The fact also remains that, as per the prayer made in the suit, the defendants were to execute the sale deed. The Learned Counsel submits that in a case where there is a subsequent sale deed after the agreement of sale, the subsequent purchaser can join in to execute the sale deed.
Yes.
And therefore, this observation of the Learned First Appellate Court that he may not enter into the readiness and willingness on the part of the plaintiff merely on the ground that the sale deed was executed is not in accordance with law. However, the finding of fact was recorded by the Learned Trial Court, and in view of the pleadings and the materials on record, there is no dispute that there was readiness and willingness on the part of the plaintiff to perform his part of the contract. Yeah.
There's one judgment passed by your lordship on this line.
इसीलिए हम लिखा रहे ना, हमको तो लॉ डिसाइड करना, बहस नहीं करेंगे तो क्या करें?
Your lordship has already.
I know. You see, this issue has been decided by a earlier 1953 judgment. Subsequently, there was another judgment that you have to necessarily challenge the sale deed, and thereafter there is another judgment to resolve the conflict that he may be directed to join in. And relief as prayed for in this suit is directing all the defendants to execute the sale deed. यही है, this is the law. इसमें तो कोई doubt नहीं है. अगर इसलिए लिखा है क्योंकि अगर उनको इस पे कुछ बोलना है तो he will have an opportunity to say. ठीक है?
And with regard to readiness and willingness, even otherwise, your lordship, I've already stated no denial. Second, that question never came.
That I have already recorded.
Yes, that is all.
That is all. अब आपको कल बहस करना है? The Learned Counsel for the respondents has submitted that the matter be posted tomorrow at 10:30 for his response. ये भी order upload हो जाए. ठीक है? इसको type कर लेंगे. अभी जिसको भेजना है उनको भेजिए. ये वाला देखिए. I just tell you. इसमें से पैराग्राफ नंबर MA का जो ऑर्डर है इसका रिकॉर्ड आया हुआ हमारे पास. पैराग्राफ 4 and 5 इसको कोट कर लेंगे. इसका जो PW11 का जो एविडेंस है ना, वो एविडेंस देखिए तो कितना है, उसको टाइप करने के लिए. PW11 का एविडेंस देख लेंगे. PW11 is the plaintiff himself. We have seen that he has stated that he is ready. फिर भी थोड़ा सा देख लेंगे.
ठीक.
11.
PW19.
No, sorry, PW19.
हाँ.
PW19.
PW11 is
Sorry, PW19 is the plaintiff himself. ठीक है?
ठीक.
हाँ उसी के साथ फाइल के साथ और इतना फाइल और आपको ना इसी की जरूरत पड़ेगी है ना, इतना फाइल और वो जो पुराना वाला जजमेंट है एमए का। हर्षवर्धन अपना नाम ईमेल आईडी सब लिख के दीजिए उसको जस्ट फॉर योर नेक्स्ट एमएलएस।
From supplementary list for hearing under order 41/11, item 403, second appeal 57 of 2019.
डेटा प्रोग्रेस की प्रोफाइल नंबर इसका किसी को मुकुल जी को बोलिएगा हम नहीं जानते नंबर मंगाने की जरूरत नहीं, वो शाम को आएगी इस देर हाँ वहाँ पे खाली निकाल यस मैडम।
Respondent number 4 died 1 month ago. For which time?
Essay number 67 of 2019. Counsel for the appellant submits that the respondent number 4 has expired around 4 months ago.
4 weeks.
Around 4 weeks ago.
No,
much?
1 month.
4 weeks.
Time period पूछ रहे हैं substitution petition में फाइल करने के 4 weeks में.
कितना दिन पहले मरे?
1 month.
4 हफ्ता 1 month एक ही बात है ना? She prays for adjournment. Post on 9th of September.
Item 404, second appeal 68 of 2019.
appealant तो है नहीं. They had stated that they are not in contact with the clients and therefore they had no instructions on the last date. आज dismiss कर देते. Essay number 68 of 2019. Nobody appears on behalf of the appellant. Counsel for the respondents is present. On 5th of August 2025, it was submitted by the. नहीं, आपने कहा था कि आपको कॉन्टैक्ट नहीं.
हाँ मैंने हम कहा हम कहते हैं कि on that day it was listed for mediation.
ठीक, हाँ सॉरी आपने कहा था क्या. The matter was adjourned at the instance of the appellant and it was directed to be placed today. Neither any advance information seeking adjournment has been circulated, nor anybody is present in the court to seek adjournment. However, the matter is adjourned and is directed to be listed on 9th of September 2025, subject to payment of cost of rupees 20,000 to be deposited. और advocate clerk association का जो detail है, the proof regarding deposit of rupees 20,000 should be filed in this case prior to the latest by 4th of September, failing which this appeal shall stand dismissed without reference to the bench and will not be listed on 9th of September.
Item 405, second appeal 102 of 2025.
What is it?
This appeal is directed against concurring judgments passed in eviction suit. The eviction suit was on the ground of person pronouncement necessity as well as particular provision of rent. And both has been taken in favor of the plaintiff as pronounce.
You are for the
Defendant
landlord or tenant?
I am the tenant, but I am the defendant.
Yes, you are for the tenant?
I have claimed that I am there is no relationship of landlord or tenant between the parties.
That is the sole issue.
हाँ, मुझे भाई नहीं In the suit,
Let us see the case of the respective parties.
the case of the plaintiff. The case of the plaintiff is that one Byaso Devi was my tenant, defendant's tenant. Defendant's landlord, sorry. One Byaso Devi was who is the vendor of the
You
plaintiff.
read para number 2 of the trial court judgment.
Trial court. ये बहुत बड़ा सा दिया हुआ है।
कोई बात नहीं, आप चिंता मत करिए, पढ़िए.
Plaintiff's case in deep the property allowing other municipal survey plots and holding was acquired by one Rupa Ram Chaudhary through family partition in the year 1925. She, on account of natural love and affection, executed the registered deed of gift dated 14/12/1935 in favor of Pratapi Devi with respect to the above mentioned property, who accepted the same and carrying possession over the same. Said Pratapi Devi also, on account of natural love and affection, executed the registered deed of gift dated section 13/4/1954 in favor of daughter Byaso Devi who accepted the same and came in possession of the district property and other property. Said we also they will transfer the district property to the plaintiff who registered deed of sale dated 4/4/19. There was a title suit. उसके बाद और बहुत सारा ये this is the rest of the vendor. हम आगे बढ़ जाते हैं थोड़ा सा. Defendant in the month-to-month tenant with respect to the premises in the such on the rent of 60 rupees per month payable to the economic month or before 7th or subsequent month since it was the purchase made by the tenant. And after the purchase of premises immediately verbally requested the defendant regarding purchase of the requested and defendant to atone him as a landlord and start making payment of rent for him from up to 1990 and onward.
Got it. What is the defense?
Defense
Defendant's case.
Yeah. Defendant's case is that I am not the tenant.
Just a minute.
I am challenged.
तो मुकुल जी के पास एक फाइल भेजे हैं आज करेक्शन के लिए. उसमें एक जजमेंट का रेफरेंस है 2015 का कुछ है. उनको बोलिए देखा है. Continue please.
And my case is defendant paragraph 4. I have been at
You
last,
did you
last
did your
two
case.
last 2 nights.
Okay.
Page number ending page number 58. There is no relationship landlord and tenant between the plaintiff and the defendant. ये है मेरा बेसिक केस. Plaintiff's case is
आप पढ़िए आगे पढ़िए.
हाँ plaintiff's case is
You
that
read forward. आगे पढ़िए.
you see the period the defendant is liable to be evicted because of the default of payment of rent is equally baseless और डिनाई किया बाकी सब. मैं एक ही केस निकाल छोटा सा पॉइंट है बस कि हम रिलेशनशिप को डिनाई किए हैं वो इशू फ्रेम. ये केस को डील किया गया है अन्य ट्रायल कोर्ट के द्वारा एट पेज 67 यानी कि 67 at paragraph 80. हम आए में आप प्लेन डब्ल्यूएस paragraph 80.
18.
Even if the plaintiff proves his title but fails to prove the existence of relationship of landlord and tenant, suit for eviction will fail. Plaintiff is bound to prove himself as landlord within the meaning of section 2 Act of the Act of 1982, showing his entitlement to receive the rent. Admittedly, no written document with respect to tenancy has been brought on record. So far as the oral evidence is concerned, PW2 in paragraph 8 and 9 of his cross-examination stated that he has heard the fact of tenancy from the Anand Prakash, who used to tell him the entitlement to receive the rent of rupees 60 per month. He also admitted that on the basis of information given by the Anand Prakash, he gave his evidence regarding the default payment of rent. Similarly, PW3 in paragraph 3 stated that the father of the plaintiff disclosed him that the monthly rent of the supervisor is rupees 60. He did not have any personal information of this dispute. PW5 in paragraph 8 also admitted in his presence no transaction took place between Subhash Poddar and Vasudevi, nor he had seen any document. PW7 also stated in cross-examination not seen any issue of tenancy. Conclusion is that certainly evidence of the witnesses are not direct to prove the fact of tenancy. Their evidence in support of tenancy is hearsay in nature. All witnesses examined on behalf of the defendant denied the relationship of landlord and tenant. It is quite fact that the plaintiff has failed to elicit anything substantial to establish the relationship between the parties during crossing of the witnesses. This is the finding of the trial court. But what the learned trial court did, that relying on a portion of discussion in a judgment in which I was not a party, but I deposed in that suit. A portion, and very next page, page number 69.
ऐसे जंप करके हम नहीं पढ़ते हैं.
पढ़ सकते पूरे. हाँ, आगे वही तो दिया हुआ PW5 in paragraph 7 stated that Vyasu Devi disclosed him about her relationship with Subhash Poddar. Evidence of this witness relevant to show that conduct of the said Vyasu Devi, who stated Subhash Poddar as her tenant. Plaintiff in his plaint as well as in evidence as TW6 stated immediately after purchasing the land, he intimated defendant to adorn him as landlord, and also immediately his vendor Vyasu Devi requested the defendant to adorn the plaintiff as landlord and pay the rent. Plaintiff remained intact in his cross-examination and no question has been put forward to dispute the conduct. This fact is also relevant to show the conduct of the vendor Vyasu Devi, who treated the defendant as a landlord and made verbal request. It has been argued that said Vyasu Devi has not been examined in the suit to prove the tenancy. It appears from the evidence of PW6 in paragraph 6 of the cross-examination that Vyasu Devi has already died, therefore it is quite reasonable that her evidence could not be adduced in this suit. Moreover, plaintiff purchased the suit in the year 1990. Therefore, he will account for all the events which took place after purchase of the suit, and will give evidence prior to the period only, on the basis of conduct and information received from the earlier owner. Apart from that evidence, it appears from the judgment of the title suit number 125/1989, that is Exhibit 3, in page 49, paragraph 22, a judgment of proportion. While discussing the evidence, it was observed by the court as paragraph 22. Let us now turn to the oral evidence adduced on behalf of the plaintiff in support of their case. PW1 Subhash Chandra Poddar and the defendant claims to be a tenant in a portion of holding number 930, that is a portion of Schedule 1B property. He had stated in examination in chief that it pays rent to Guru Works and Dilawar Singh. Vyasu Devi nahi aata. And he remitted
Who are Guru Works and Dilawar Singh?
They are co-sellers of they are co-sellers of that Vyasu Devi. There were some litigations between Dilawar Singh, who works for Gauri Devi, who is the sister of the Vyasu Devi, and that was the suit 125, 125, 89. In that suit, I was not a party. During the pendency of that suit, the Senate was affected in favor of the plaintiff. As discussed above, the evidence made in title suit number 125/89 clearly show that the purchased defendant Subhash Prabha, who was examined in PW1 in the title suit 125, claimed himself to be the tenant of Guru Works and Dilawar Singh. In the present suit, defendant has claimed himself as hostile owner, having an adverse possession of unsold property for the last 60 years, but his admission made in title suit number clearly falsified possession. Even though the said title suit was dismissed, but it could not take away the admission made through the evidence by Subhash Chandra Poddar, and also the said judgment passed in title suit number 125/89 not final, and it has been modified in terms of compromise decree title appeal number 268/95. The first appeal. The claimed admitted landlord of Subhash Chandra Poddar, namely Guru Works, was plaintiff number 2, and Dilawar Singh was defendant number 1, and the vendor of the plaintiff Vyasu Devi was defendant number 4 in the one of the one and same suit, that is title suit number 125/89. Further suit property was transferred by the Vyasu Devi in favor of plaintiff to register deed of sale at 4490 at it appears from Exhibit 7, which is the decree of appellate court, that Guru Works was the appellate number 1, and on the account of death of Dilawar Singh, his legal heirs were respondent number 1A, 1B, and vendor Vyasu Devi was respondent number 2, and the present plaintiff was respondent number 5. That said appeal number 268 of 1985 was disposed of in terms of compromise petition, which was made a part of the decree. Compromise petition suggests that it was agreed between all the parties to that appeal that purchaser of Vyasu Devi will have absolute right, title, interest, and possession over the property purchased by them to register deed of sale. It was also agreed that neither the appellant nor the heirs of the deceased shall have any right, title, and interest with respect to the property in the suit. Therefore, it is clearly evident from the decree passed by the appellate court. Appellate court is the title of the plaintiff of the suit property purchased to Vyasu Devi, and and duly has been recognized and admitted by the admitted landlord of the defendant, namely Gulbarg Square and Lavas. In light of the above discussed fact, it can also be said that any defendant which was attached to the title of the plaintiff pursuant to the CLD dated 4490 has been revoked in appeal number 37, 1998. Inference in relation between defendant and Gulbarg and Lavas can also be drawn from the gross examination of the paragraph 11 of PW5 and PW9, paragraph 9 of PW6, which shows that it will well within knowledge of the defendant that Lavas and Gulbarg are also claiming interest of the property. That was it.
Yes, I'm hearing.
After the transfer and acquiring title, evidence of record has that therefore written a notice dated such and such was issued to the defendant by plaintiff intimating regarding the purchase made on 4490 and also judgment and decree dated 30th July 1998 and request was made to defendant to attend plaintiff as a landlord. Exhibit 1 by this shows that said notice was issued to registered court. In such circumstances, there is always mention of due service notice. Even if such notice had not been issued, then also adjournment is not necessary condition to create landlord relations between the parties. It is clear from the evidence on record that plaintiff has established his title and also issued notice to defendant about purchase. It is not the case of the defendant that earlier landlord is demanding rent from him. It is not necessary that rent must accept landlord, the plaintiff as landlord, and then alone he is liable to pay rent. I effectively that rather after establishment of title by new landlord, the tenant is bound to pay rent to the new landlord. It is also argued that Exhibit 7, the name of only one purchaser, Shiv Kumar Gupta, was mentioned in the for his entitlement of realized rent from the tenant. Such argument is not invalid on the admitted note that the defendant Subhasan Gupta accepting himself a tenant and on point of transfer of property in favor of the plaintiff Vyasu through Vyasu Devi. Even if no right of the plaintiff is mentioned in the compromise agreement, it is not in any way damage the right of the plaintiff as landlord to recover rent from the supplier और वो landlord ने मान ली. हम कहीं नहीं बोले हैं कि हम व्यासो देवी के ये मेकिंग ए कंप्लीटली थर्ड केस कि हमने एक एविडेंस में डिपोजिशन में माना है कि दिलावर सिंह एंड गुलबर्ग स्क्वायर वाज माय लैंडलॉर्ड
And they are the relatives of Vyasudev.
Distant related.
And ultimately,
but they lost this.
They lost the suit and which ended into a compromise, and the title of Vyasodevi was recognized by them.
What has happened? That in the year 1990 he purchased plaintiff 89. In the year 1999, and then 99, there was a compromise between the original plaintiff and the original defendant of that registry.
Is it there in the record?
Exhibit 7. There.
So show me the discussion. There was a compromise. Yes, they are talking about one compromise.
No,
At the appellate
only
stage.
the purchasers of the Vyaso Devi and the Gauri Devi were also being added to the party to the compromise. In the compromise, all the purchasers have been mentioned in the covenant petition, and only one of the purchasers has been assigned the right to realize rent from the tenant. The plaintiff.
You admitted that you are a tenant and under Gulbarg Singh and this person. You admitted that was
The
your
error of
admission.
record. I admitted that I was a tenant of the lovers in the first one in respect of plot number 1361 that had been concealed. I also and not 1461. In this suit, the plot number 1461 is there. In my IA, I have annexed the judgment.
Which judgment?
Exhibit 7. The judgment which is being relied by the
No, your deposition. Where is that deposition?
deposition.
Yes, because
Deposition
your
also
deposition,
there.
your deposition was relied
deposition,
upon.
no, deposition, my certificate to go deposition has not been filed. not have been confronted to me. That should have been confronted to me while I depositing in this suit. That has been confronted. Only a portion of the judgment has been taken. That portion of the judgment is in at page 136 of my IA. 88 is the judgment. 136. Should I read? That portion has been cropped up. Only a portion. Paragraph 22. यही बोला जा रहा था ना, यहाँ पर जो बोला गया है वो दैट इज लेटेस्ट जजमेंट का पार्ट वहाँ से उठाया गया था. Now let us turn to the oral evidence adduced on behalf of the plaintiff in support of their case. PW1 Subhash Poddar claims to a tenant in a portion of holding number 930, that is a portion of Schedule B property. He had stated in examination in chief that he pays rent to the Gurva Squad and the Lava Singh, and he remitted rent through money orders. He had proved as many as 28 money order coupons marked as Exhibit 1 series. In his cross examination, he had admitted that there is no seal of the post office in any of the money order coupons. He further stated that the corresponding plot number, the holding number 930 is 1361, not 4061. This part of his evidence is incorrect. There is no disputed plot number 1361 in the schedule of the plot. उसमें भी नहीं था, इसमें भी नहीं है. इसमें 4061 है. इस प्लॉट को इसको छोड़ दिए. और after all discussion, the Landlord court found that his requisition cannot be supposed to be true. And only on the basis of this very requisition, the Landlord trial court, on a completely different basis, I am admitted the tenant of Gurva and the Lava Singh, therefore that I am the tenant of the plaintiff. I am permitted to read the 145 of the evidence. That deposition was not being filed, not being executed. 145, New Act is 148.
Yes.
Cross-examination as to the previous statement in writing. A witness may be cross-examined as to the previous statement made by him in writing or reduced into writing and relevant to matters in question without such writing being shown to him or being proved. But if it is intended to contradict him by the writing, his attention must be, before the writing can be proved, be called to those parts of it which are to be used for the purpose of contradicting him. That has not been done. The original deposition was also not been produced, and this was not a case of the plaintiff that the defendant was a tenant under the Lava Singh and Gurva Squad. Never. When a completely third case was made out, there, my third point is regarding law, question of law, that whether that compromise, unregistered compromise decree can be construed as a transfer or atonement of tenancy. For assignment of tenancy, there should be a proper transfer or atonement. I have never atoned the defendant as my landlord. I am not there will transfer from the Lava Singh or Gurva Singh to the plaintiff. Now, the what appellate court did, kindly turn to page number 46 now. 46, paragraph 19. Before that, paragraph 55, I would like to draw your attention. Paragraph 18. Landlord counsel appearing on behalf of the appellant, paragraph 89 reading, has also contended that the settled law is that before relying upon the statement of the witness given in earlier suit, the witness should have been confronted with the testimony person made in another case to get a response and explanation with that particular statement. It has been submitted that the veracity of correctness of the statement of the must be tested by the right of an opportunity of question answer, and the witness should be confronted with the said statement as provided under section 145 of the Evidence Act.
This, your evidence was not exhibited before the court.
My evidence? No, not at all. The original evidence was not produced, not exhibited, not produced even. Only a portion of the discussion was taken. Let us now finding on the paragraph 19. That is the finding of the NCL. The net counsel for the defendant appellant has also contended the wrong approach in finding fault in defendant case has been adopted by the trial court as it is established law. When the plaintiff has come up with the suit, it was bounden duty to stand on his own leg. It was also contended that the very foundation of the suit of the plaintiff was that the defendant was tenant of the plaintiff vendor.
Were you a party in the said suit? In the earlier suit?
I was not part.
You were just a witness.
I was just a witness. And how the London trial appellate court did that is my condition was reported that it was a bounded duty of the state only. It was also contended that the very foundation of the suit of the plaintiff that the defendant was tenant of the plaintiff vendor Vyasudevi, and therefore the Landlord court committed error by making a third case, taking a cue from the statement of the defendant in an earlier suit that he was tenant under good works and Lower Singh, and therefore he was tenant of the plaintiff. However, I do not.
You see, your case was you pleaded that you were month-to-month tenant with respect to the premises on a rent of ₹60 only.
I have pleaded.
ये क्या है para 3?
Paragraph?
Para 3 of the appellate court judgment.
No.
पढ़िए ना, para 3 क्या है? Paragraph 3.
Now this is the case of the plaintiff. Yes, ma'am.
It has been pleaded.
How?
This is the case of the plaintiff.
The case of the plaintiff. Or girls is
ये para 5. Para 5. What was your case? How were you in possession of the property?
My case was that I was in possession of this property.
In what capacity? You had some
as
title.
in open assertion of my own right, and
How? What was your right? You had a say deed in your favor.
no, I was not suspended. I have also challenged, but there is in the relationship I cannot challenge the title of the plaintiff, and that issue might not be taken up. Incidentally, may be gone into a case where personal necessity has been was a ground of the evidence. But everywhere I denied that neither I was a tenant of the Vyasudevi, nor I am the tenant of the defendant at any point of time. And it is the duty of the plaintiff to study on only. Any lecture, even if on my part, that cannot help me. referring at paragraph 19 of the affiliate. Should I continue paragraph 19? Finding of the landlord trial, affiliate, first affiliate. He simply said that however, I do not find any merit to the contents of the affidavit, where one party of the suit claimed the defendant possession in the suit property was the result of creation of LLC, and the party claimed relationship with landlord-tenant on the basis of derivative title and ownership. On the other hand, the second party defendants claim his position in open assertion of title and hostile possession with evidence to lead to establish such relationship, and in particularly if
You were claiming adverse possession.
adverse
Possession against whom?
whoever comes with
Whoever
this title,
means, as a, you have to declare, no, you are seeking adverse possession against somebody.
that is
You
my
will,
letter.
you
That
will
is my
claim
letter.
adverse possession against somebody and say that your title has been perfected by way of adverse possession against Mr. So-and-so, who is the true owner of the
That
property.
should be. That should be.
Yes.
For
So
meaning
against whom were
owner.
you
I'm
claiming?
not the owner. I'm not saying as my owner.
That you were claiming adverse possession. Against whom were you claiming adverse possession?
My words are there in the WS. WS I added.
Words come back.
Yeah.
Against whom were you claiming?
I have said I am coming in possession in the suit property for more than 60 years in open assertions of my right to claim interest.
That's right.
That is
Against whom?
I have disclosed. I haven't disclosed.
You haven't disclosed. So you are claiming adverse possession without any true owner of the property on record.
No.
Then you will claim, you
Whoever
cannot have
comes.
an adverse
Whoever comes.
possession in rem. Can you have an adverse possession in rem?
No.
You can, it has to be in personal.
Has to
So
be in
therefore
personal.
you were claiming adverse possession against whom?
That is the truth they put that I have claimed adverse possession and I haven't proved that against
So
whom
you
or
have not- yes.
the Daniel.
Yes.
So that is the plaintiff has to prove his case on case. Na? I have not brought any case. Or that admission is deemed to have been admission on my part. One that I am the tenant of the plaintiff. How come? That cannot be. That is the defendant's third case beyond the pleading of the plaintiff. Here is the division and judgment of the Honorable Supreme Court. My only case is that it is the plaintiff who has to establish that I am looking at under. And yet, the trial court also had the valid appellate court also. There is no adjournment and there is no transfer. Even if in worst cases I may be into the creatinine under the dilaversin is either two in respect of another, a different 1361, not 1461. Here is the suit code is 1461.
Okay. Or the learned counsel appearing on behalf of the appellant.
I was will add a judgment of the law.
This one? Which paragraph?
68. 69. Subclause 7.
69.
Subclause 7.
Yes.
The court cannot travel beyond the pleading as no party can lead the evidence on an issue or point not raised in the pleading, and in case such evidence has been adduced or a finding of fact has been recorded by the court, it is just to be ignored. Though it may be a different case
Which is that finding which is beyond the pleadings?
that I was not the tenant of Basudi.
This you contended that you are not the tenant
And
of.
as per the plaintiff, I was the tenant under Vyasudevi at a rental of ₹60. This is the basic case of the plaintiff. That was not the case that I was a tenant of Dilawar Singh or the Works. Never. They were also seeking the claiming the title.
They are the co-owner of the suit.
No, they are also claiming title, and there is a dispute between them. Not a co-owner. They were claiming title. They were also claiming title. About the suit. And that third case, how we become the tenant of Yasudev or the plaintiff through Satpal Singh or the Works. And Farmai Jitri was also a unregistered sale deed, unregistered instrument, Farmai Jitri, unregistered Farmai Jitri, and that is barred under section 17 of the Registration Act. Title or
Which substantial question of law are you referring to?
That's it. Mainly, I have in the memo of appeal, page 18. First, page 18. C. Whether the impute judgment and decree passed by the Landlord Trial Court and Landlord Appellate Court is to be said as relief had been granted on the basis of fact which have not been pleaded. Second one is whether the statement made by the victim in any other suit wherein accepted being a tenant of a third person can be said to be admission on the part of the respect of the having a landlord in relationship with the plaintiff.
You heard the learned counsel for the appellant. The learned counsel for the appellant has submitted that though there are concurrent findings with regard to landlord-tenant relationship by both the courts, but substantial question of law arises in this case. He has submitted that it was never the case of the plaintiff. It was the specific case of the plaintiff that the defendant was the tenant of Gyasu Devi, who is the vendor of the plaintiff. And the learned trial court has travelled beyond pleadings in as much as the learned trial court has relied upon the title suit, the judgment in title suit number 125 of 1989, wherein it was recorded that the defendant had claimed that he was paying rent to Goodbert, Scott and Dilawar Singh. The learned counsel has further submitted that the trial court further committed an illegality by relying upon the compromise decree, on the basis of which the title was conferred upon Gyasodevi. Yes,
The transfer was held.
that's right. Was conferred upon Gyasodevi by virtue of compromise decree. Gyasodevi को मिला था ना? In this compromise.
मैं चैप्टर सेल के बाद हुआ था एक में,
अच्छा.
उसमें हमारे जो ट्रांसफरी लोग थे सब पार्टी बने, तो वैलिडेटेड पार्टी फर्स्ट, और जो सेल हो गया था उसको सब बोल दिया था.
तो उसका तो ऑलरेडी रजिस्ट्रेशन हो गया था ना,
इसका
सेल जो हो गया था.
सेल का हो गया, जिसमें पैसा का लेन देन भी हुआ.
Subsequent in compromise.
हाँ, है कॉम्प्रोमाइज है इसमें है. और
Just a moment. The learned counsel has submitted that the learned court has relied upon the compromise decree in which certain transaction of money was also recorded, but the same could not be relied upon as it was an unregistered document and hit by section 17 of the Registration Act. In view of the submissions made by the learned counsel for the appellant, this appeal
also
is admitted for final hearing on the following substantial question of law: whether the impugned judgments and decree passed by the learned courts is vitiated as the courts have considered the third case, inasmuch as which was not pleaded by either parties, inasmuch as the court recorded that the plaintiff was paying rent to Gurbat Kaur and Dilawar Singh. And there is yes, please take it this way. Whether the judgment passed by the both courts is vitiated on account of court travelling beyond the pleadings of the respective parties. Whether ये एक हो गया, दूसरा whether the
आई को जो देखा जाएगा
whether the
वो ज़्यादा अच्छा है. At 20
yes I कर दीजिएगा, ठीक है? Can be treated to be an admission, है ना? I
and adjournment वाला that
yes. Whether the एक हो गया दो और H H
H
right?
right.
H and I issue notice to the respondents for which notice under ordinary process as well as pre-post be filed by the appellant within a period of by day after tomorrow. Post this case,
एक आई
awaiting service report. इसीलिए आपको 2 दिन का टाइम दिया.
3 दिन में जो देखा जाएगा
Just a moment. कुछ नहीं हो रहा. Close this case on 28th of August. Awaiting service report. Office to tracks will post it. It will be open to the Dusty in addition. It will be open to the applicant to serve notice to the respondent through the counsel who may be appearing before the executing court and be presenting the respondent. The affidavit regarding service of notice through Dusty be also filed before this court at the earliest and much prior to the next date of hearing. Yeah. Next case.
From date list item 1, second appeal 120 of 1998.
Serial number?
504.
What have I done?
The whole week last, my lord, I was badly ill, my lord, suffering from flu, and today also, my lord, I am not well, my lord.
Sir, DFD किए हैं, restoration कराएंगे. What is this one? DFD नहीं किए हैं, आपको cost लगाएं. SA number 120 of 98. Who is there for the
Item one.
appellant?
जो कॉस्ट उसमें सुना कि 20,000
लगाए हैं ना, ठीक ही लगाए हैं. आपके जूनियर को भी तो कहाँ होश था, वो भी बीमार चल रहे हैं क्या? He is also ill.
बैक पार्टन
कोई बात नहीं, 20,000 रुपए देके आपका DFD नहीं किए केस, बस एक खुशी मनाइए. DFD कर देते तो रेस्टोरेशन करने में भी बहुत टाइम लग जाता, 20,000 से ज्यादा खर्चा हो जाता. Yes, who is for the appellant?
बैक पार्टन
Last time ये take up हुआ था केस में. Vijay Kumar Ray, learned counsel for the appellant, is seriously ill. Nobody appears on behalf of the appellant. No petition seeking, no advance notice has been circulated for adjournment. On 10/7/2025, at the prayer of the appellant, the matter was directed to be listed on 15/7/2025 with a clear indication that no further adjournment will be granted on the next date of hearing. When the case was taken up on 15 July 2025, a submission was made that the wife of the arguing counsel is seriously ill, and a prayer for adjournment for 2 weeks' time was allowed, and the matter was directed to be listed on 31/7/2025.
Item 1.
सर, आपका केस हम DFD करने वाले थे, आप दिख गए तो हम रुक गए. सर, आप यहाँ रहेंगे तो उनको कैसे पता चलेगा उनका केस चल रहा है? हाँ, चलिए बहस करिए.
इसमें एक एकोमोडेशन
भी एकोमोडेशन नहीं देंगे.
हम बता रहे हैं अपना
नहीं, हमको कुछ नहीं सुनना है. आपके इंस्टेंस पे लास्ट चांस हुआ, फिर आपके फैमिली में प्रॉब्लम के कारण फिर डेट हुआ, और आज आपको हम टाइम नहीं देंगे. बस अभी कॉस्ट लगाने वाले थे, अगर आप रहेंगे तो भी कॉस्ट लगा के एडजर्न कर देंगे. 20,000 रुपए से कॉस्ट कम नहीं लगेगा. उनका केस में 20,000 लगा है. आज का बेंचमार्क 20,000 रुपीज फॉर एन एडजर्नमेंट. इफ यू वांट आई विल गिव यू एडजर्नमेंट.
मेरा कारण सुन
कोई कारण नहीं सुने। 98 का मैटर है, हम कोई कारण नहीं सुने।
ऐसा होता है ना, मार्क नहीं कर पाए।
नहीं, बहुत अच्छी बात है, नहीं कर पाए तो।
बीबी कुमार के नाम से आता है,
नहीं,
हमको
कोई बात नहीं।
नहीं आता है मेरे
नहीं,
खिलाफ।
तो फिर आप कैसे आगे मार्क नहीं कर पाए तो?
हमको बताया ना।
नहीं नहीं, आपको रेस्पोंडेंट बताते हैं कि आपका केस लिस्ट में लगा।
जी।
बहुत अच्छी बात है।
बताएं।
इट्स वेरी हैप्पी स्टेट ऑफ अफेयर्स। आप बहुत अच्छे हैं, इनको बताते हैं कि आपका केस लगा हुआ है, चलिए एडजर्नमेंट मांग लीजिए आज। नहीं, आज नहीं होगा टाइम।
आज भर सिर्फ आज।
कोई बात नहीं, आप लिख दीजिए तो वही इनका अपीयरेंस भी रिकॉर्ड कर लीजिए। द लर्नड काउंसिल इज सीकिंग एडजर्नमेंट।
20
कोई बात नहीं, नहीं दे पाएगी तो कोई बात।
इसमें हम लोग को एक पैसा फी भी नहीं दे पाती।
कोई बात नहीं ना,
लेबरर है, लेडी है, लेबरर 78 और 80 इयर्स की ओल्ड है।
इसके पहले कि वो मर जाए।
जी।
सबको मरना है, हमको आपको इस केस को आप आर्ग्यू नहीं करना चाहते।
नहीं, हम
सब्स्टिट्यूशन का वेट कर रहे हैं।
एकदम चाहते हैं।
नहीं चाहते हैं सर, प्लीज डोंट टेल अस। ये सब कहानी मत सुनाइए। 98 से यहाँ पे सूट कब का है ये?
डे आफ्टर टुमारो।
सूट कब का है बताइए? सूट कब का है?
91 का।
हाँ, 91 का सूट है। हाँ बताइए, हम तो प्रैक्टिस भी नहीं शुरू किए थे 91 में। आप शुरू कर लिया होंगे, आप सीनियर हैं हमसे। नहीं, हम एडजर्न नहीं करेंगे सर। आपको एडजर्नमेंट चाहिए, 20,000 रुपये कॉस्ट देना पड़ेगा।
एक दिन का सिर्फ
नहीं देंगे, एक दिन का भी टाइम।
एक बाई नहीं दे पाएंगे।
रिजेक्टेड उनको नहीं दिए, आपको कैसे देंगे? आर्टिकल 14 वायलेट हो जाएगा।
मेरा रीजन है, मेरा
नहीं,
रीजन
कोई
है कि
reason
हम मार्क नहीं कर पाए। बीबी कुमार के नाम से ही एक ही केस मेरा बीबी कुमार के नाम से है, और वो आता नहीं है। हम लोग जो अपना इसमें देखते हैं,
बहुत गलती है अपने हाईकोर्ट का कि आपको मैसेज देते हैं। आपको चिट्ठी लिख के भेजें कि आपका केस लगा हुआ है? शुड वी गिव यू लेटर्स,
हम
इनविटेशन कार्ड?
ये हम नहीं कर।
तो फिर नहीं, आप एडजर्न नहीं करेंगे सर, बिल्कुल नहीं करेंगे एडजर्न। आप अपना फाइल घर से लेकर आइए और सेकंड हाफ में बहस करिए। हम इस केस को एडजर्न नहीं करेंगे। और जो आज टाइम मांगेगा पुराने केसेस में, आज 20,000 रुपये से एक पैसा भी कॉस्ट कम नहीं करने वाला। फाइल लेके आना। सेकंड हाफ में कोई केस नहीं रखे है ना? कोई बैच मैटर में तो कोई दिक्कत नहीं। चलिए आपका करेंगे, उसके बाद इनका सुनिए।
My case will be, I will argue not.
Prayer is refused. चलिए कॉल करिए।
I will argue.
सर ऐसे नहीं होता है,
तो 20,000 रुपये होता है।
कोई बात नहीं।
Item 2, second appeal 97 of 2004.
Appellant. Yes, Mr. Das, what is your case? रेस्पोंडेंट की तरफ से कौन है? चलिए आज
25 the suit for cancellation of salary executed by defendant number 1 in favor of defendant number 2.
just a minute. Plaintiff, you are the plaintiff or the defendant?
I am defendant.
Concurrent findings?
No, it is reverse. The High Court dismissed the suit, appealed to the law.
Judgment of reversal. What was the suit for?
Suit for cancellation of sale deed. Declare the sale deed null and void, executed by defendant number 1 in favor of defendant number 2.
What was the ground for cancellation? Primarily.
You said that rent is very big thing, it does not disclose any ground, but it says that it is a joint family property, so without consent of the plaintiff, defendant number 1 sold it to defendant number 2. Genealogy is admitted, they somehow all related to each other. Either
Is there any bar in selling undivided portion of this joint family?
undivided portion, there is no bar to the extent of his or her share, you can sell it. to
Sale
anyone.
deed will be valid only to that extent.
To that extent. And
The sale deed has been declared to be null and void.
total that cannot be declared. To the extent it is not that he didn't file for partition of the suit properties, because they say admittedly says that one Gokul Kumar who has acquired the property.
The defendant, after purchasing the property, did not apply for partition. The purchaser has a right to claim partition.
Part is a residential house where his father-in-law used to reside earlier, where now he along with his wife and children residing there. And these facts are all admitted.
What is the law relating to sale of undivided portion of the suit property?
Undivided portion that anybody makes a grievance that he has sold some prime property in excess of his share, then he can go for partition, and to the extent of the excess of sale, that can be declared null and void. That is not the entire sale date will be declared because
Do you have any judgment on this? We have to put it in our judgment, no? This is the law. Because recently I have not done on any judgment on this, so I just wanted to know. Where is the judgment on this aspect of the matter? Let us see the judgment of the client. आप जजमेंट खोज के लेके आएंगे, ऐसे कैसे चलेगा? तो हाफ हार्टेड तरीके से करेंगे तो वैसे ही आधा आधा जजमेंट हम भी करेंगे. So there are two substantial questions of law. Whether the plaintiff has got any locus. What do you have to say to this?
Locus standing as plaintiff, sale deed was executed by defendant number 1 in favor of defendant number 2. So whatever the defendant number 1 can say that consideration not paid or something illegally or it was got the sale deed executed, that is the defendant number 1 who can say. But plaintiff, who is another co-sharer, he cannot straightway say that sale deed executed by defendant number 1 in favor of defendant number 2 is null and void.
And without consideration. That was the ground taken. Was that the ground taken? Ground was taken undivided portion of the suit property.
The plaintiff में कोई ground नहीं लिया है. It is in the appellate court always
Plaintiff में कोई ground नहीं लिए है cancellation of sale deed.
only pled that this is the share, this is their joint
That's
property,
right. So
co-sharer, and so this sale deed executed by defendant number 1 in favor of defendant number 2 may be declared null and void. A simple prayer like
simple prayer. The co-sharer of a property says
this.
that the sale deed executed by the defendant number 2, defendant number 1 in favor of defendant number 2 is null and void. तो locus तो है ही ना, भले suit dismiss हो जाए. When you say that there is no locus, it means that a third party and some alien has come and challenged the sale.
Sale deed can be section 26 or 31 of the Specific Relief Act. Whether rectification can be done or whether cancellation can be made, making grievance by the person who has executed the sale deed.
No, a third party, मेरा property आप भेज देंगे तो I will not go for cancellation.
For that, he has to go for partition and then say that this is acceptable.
That is another thing, that the suit as framed was not maintained. That is a separate thing altogether. But otherwise the suit was maintainable. The co-sharer of the property is saying that the sale deed has been wrongly executed. Maybe that he could have come up with a plea, there was a previous partition. You never know. So on this ground, suit cannot be said to be not maintained.
But that has been disbelieved.
Sorry, previous partition has been disbelieved by both the courts.
Not disbelieved.
By both the
Because
courts.
the document was produced. This
By
is
both the courts.
Yes, both the courts. That's
Now
why-
let us see the trial court judgment. You read the case of the plaintiff as per the plaintiff. You read para 1, 2, you just read the foundational facts
There
and
is a
then.
suit for declaration that the sale deed bearing so and so, executed defendant number 1, Gayatri Devi is illegal void document, and on the basis of that sale deed, defendant number 2, Chandrika Singh, has acquired any title over the suit land. Shortly stated, the case of plaintiff is that the suit land
Which judgment are you reading? Trial court.
is a trial court, suit
Yes.
title suit.
Para number 2. The facts of the case as depicted in the plaint.
No, that is the appellate court, title appeal.
This is judgment. Oh, sorry, this is title. Okay, fine. Shortly stated. You read
Shortly
it.
stated, the case of plaintiff is that the suit land comprising Para number 25, plot number so and so, total 28 decimal, was originally recorded in the name of Shambhu Orav and others, son of so and so. The said land was purchased by one Gokul Kumar, this is the predecessor, in the year 1925 for the consideration of rupees 50 only, and therefore in the remarks column of Khatian it was noted that Gokul Kumar has purchased the land for rupees 50. Said Gokul Kumar had two sons, Bhablu Kumar and W. Kumar. Bhablu Kumar died leaving behind 5 daughters and 1 son, namely Sukri Devi, Supra Devi, Parivar Devi, who are all dead, and Gauri Devi and Bangri Devi, and a son Muneshwar Mathur, the defendant number 1, in the only daughters of Muneshwar Mathur. Gauri Devi and Bangri Devi have been made defendant 5 and 6 in this suit, and it is said that Gauri Devi is the cape of Chandrika Singh, defendant number 2. In the branch of W. Kumar, he has 2 sons, Rameshwar Kumar and Kameshwar Kumar, and Vishwanath Kumar, and defendant number 4 and 5 of the suit. The case of the plaintiff is that the land suits is joint ancestral properties of the plaintiff and defendant number 1 and 3 to 6, and the defendant number 1 has got no right to execute the transfer 17 decimals of land of the 2 plots to these sale deeds bearing so and so, dated 29/6/90, and the sale deed aforesaid is illegal, void, not binding upon the plaintiff, and defendant number 3 to 6. It is also said that in the recent survey, the draft survey record of right has been prepared in the name of plaintiff and the other co-sharer. It is said that by virtue of these sale deeds aforesaid executed by defendant number 1, the defendant number 2 have acquired no right title in the suit property, but after the execution of the sale deed, the cloud has been cast on the title of the plaintiff, and therefore the suit. The cause of action of the alleged deed is dated 29/6/90, when the sale deed was executed and registered, and the plaintiff has valued the suit at ₹3,000 and paid the court fee there. Then defendant number 1, who is executed the sale deed dated so and so, has filed separate written statement, and virtually she supported the case of plaintiff by stating that the suit land is the joint family property of the plaintiff and the defendant number 1 and 3 to 6. Our further case is that the defendant number 2 fraudulently and with ulterior motive brought this defendant at Gumla registration office after giving her assurance that he shall help her in getting loan from some government scheme. After coming at Gumla registration office, the defendant number 1 got the sale deed dated so and so executed from her in respect of 17 decimals of land of plot number 352 and 353 of khata number 25 of village Karondu. After that, this defendant disclosed that the fact that the plaintiff and her other family members, and then the present suit was filed. In paragraph 9 of the written statement, it is stated that after some time, the defendant number 2 became ready to return the suit land to this defendant, and with this, and in view of the defendant number 2 brought to defendant number 1 at Gumla registration office, and he executed the sale deed in respect of suit land, area 17 decimals, but again the paid fraud with this defendant, and instead of sale deed, he got the consideration money rupees 400 recited, which was to be paid by this defendant to Chandrika Singh. And after some time, Chandrika Singh gave a legal notice to the defendant calling upon her to pay rupees so and so consideration money of the sale deed executed by him in favor of the defendant. It is said that the defendant number 2 was to return the land to the this defendant, and as there was no question of payment of consideration money of rupees 100 by this defendant to the defendant number 2. After that, the defendant number has replied to the aforesaid notice. It is also said that the suit land is the joint family property, and therefore the defendant has got no right to execute the sale deed. The defendant number 3 and 4 have also the case of the plaintiff in the written statement. Defendant number 2 along with defendant number 5 and 6 have filed joint statement that they and contested the suit entirely on the ground that the suit is frame is not maintainable. There is no cause of action of the suit is that from Ranjanda of one Abhay Singh, in whose favor the defendant number 1 has executed the sale deed on 13/8/90 and transferred an area of 5 decimals of plot number 3 for valuable consideration of 30,000, and after purchase said Abhay Singh is in possession of the said land. It is said that the suit land was no doubt acquired by Gokul Kumar, but after his death, his two sons divided all their properties by metes and bounds. A memorandum of partition paper was also prepared in the year 1956, and in view of that partition, the suit land area 28 decimals of plot number 352 and 353 was allotted to the share of Bhavlu Kumar, who died in the year 1957, leaving behind 5 daughters and a son, Muneshwar Mahato. It is said that Muneshwar Mahato also died, leaving behind the defendant number 1, who inherited the suit land and became sole owner of in possession of the entire plot number so and so. This case of the plaintiff is that the defendant number 1 was in need of money, and therefore she negotiated to sell the suit land area 17 decimals for the consideration of rupees 3,000, and after receipt of the consideration money, she executed the sale deed on 29/6/90, and after purchase, this defendant has constructed a house over the suit land, and he is residing with his wife Gauri Devi and his children in the said house. The defendant has denied the other allegations and paid for dismissal of the suit. Now these issues, 6 issues are in time.
That's
Whether suit is
so this partition has been declined.
huh?
Partition has not been accepted,
The partition
and the defendant filed raised an objection that she had not gone to the registry office for sale of deed. She had gone for some other purpose, and she has been fraudulently. The defendant number 3 has fraudulently acted in a fraudulent manner. Defendant number. ये कौन plea raise करेगा? Co-defendant, the plaintiff.
the plaintiff prove करेगा,
Plaintiff तो नहीं करेगा ना. This plea that it has been fraudulently executed.
that is defendant number 1 has to.
Defendant number 1 had to file a specific suit for that.
Sir, वो तो नहीं किए, वो तो
तो
support
नहीं
किए
किए।
खाली plaintiff।
सपोर्ट कर दिया और बाकी जो डिफेंडेंट्स है वो प्लेंटिफ को सपोर्ट कर दिया।
नहीं, बाकी defendant
One, yes, one supported defendant
one
number.
supported plaintiff.
No, defendant number 1 supported plaintiff. Defendant number 2 to 6, they supported.
5 and 6 they are all
This
wife and sister-in-law of defendant number 2, they supported the joint with each other.
they also talked about partition.
No, talk about partition.
They talked about partition and they supported defendant number 2. Defendant number 2 along with defendant number 5 and 6 filed a joint written statement. So they were supporting each other. The sisters were supporting the defendant number 2.
5 is the wife of defendant number 2 and 6 is the sister-in-law of defendant number 2. They supported the joint together.
Okay. What about 3 and 4? They are the sisters.
They are from the branch of W, they are Ramesar's branch.
Anyways, the story of partition has been rejected.
I told you a story of partition is in this.
Now let us see the further findings.
Yes. 4 and 5, issue number 4.
You just
Partition.
forget about till paragraph number. Just. पैरा नंबर 10 पढ़िए था।
Besides the aforesaid fact, Gauri Devi had also executed the sale deed and transferred 5 decimals of Abhay Singh by exhibit A by 1, and there being jointness in the family, and then the present plaintiff ought to have filed suit land against Abhay Singh also for setting aside the sale deed in favor of in his favor dated so and so. As such, I find and hold that the defendant number 2 and 5 and 6 have succeeded in proving partition as alleged.
तो फाइंडिंग हो गया ना ट्रायल कोर्ट का। So there is a finding of partition. आगे पढ़ें। 11, para 11.
Paragraph. Defendant number 1 that the defendant number 2 fraudulently got the sale deed executed from her, and on the day of execution of the sale deed, defendant number 1 has brought her to Gumla on the pretext of help her in getting government loan. But at Gumla, the defendant number 2 got the sale deed executed from her. The sale deed executed by Gayatri Devi as in marked exhibit 1 in the suit. The settled law that the charge of fraud is a criminal charge and even in a case must be proved beyond all reasonable doubt, since the defendant number 1 has alleged that the sale deed dated so and so is a result of fraud, precision, is a practice. by
So
defendant number
fraud
2.
has not been proved.
Fraud has not been proved, neither alleged nor proved. And fraud there must be specific plea of deceiving the person. Here the sale deed was.
So the
of-
trial court held that there was a partition. The trial court rejected the plea of fraud and ultimately dismissed the suit. What about the appellate court?
Appellate court reversed it.
On both the points, on all the points.
Yes. Partition disbelief.
There was no partition,
That is
no right to
doubted
execute
about
the sale deed.
doubted about the execution. But
So the date, so the sale deed is declared null and void.
yes. On the basis of our discussion, I find and hold that there was no partition between W and W Kumar, and the family of Gokul Kumar is joined. Gayatri Devi had no right to execute the sale deed regarding the suit land without consent of the other questioner in any one's favor. So the sale deed dated 29,690 is declared null and void. The defendant number 2, Chandrika Singh, has no right to enjoy the property of his own. Now it is a residential house, living there with the family.
What is the finding with regard to fraud?
Fraud,
So let us see, they must have framed an issue. Where is the point of determination?
is para 6. There are only 2 points for determination in this appeal. Point number 1, whether their partition in between W. Kumar and W. Kumar in the year 1956. Point number 2, has Gayatri Devi sold the share to Chandrika Singh within her right to do so. As both the points are interrelated as discussed together to avoid repetition of facts, the rules to ensure documentary evidence and record of various citations derived from the research. Case of the appellant plaintiff before the Landlord court, the title suit number so and so order. Earlier, the record of right during division survey operation featured in the name of Chambu and so and so. In the remark column, the record of right it has been written that the suit land was purchased by Gokul Kumar in the year 1925 for rupees 50 only. Written statement, defendant number 2, 5 and 6. This reading is that the plaintiff as well as genealogy of the parties are admitted. In the written statement, there is in the court case that the suit property was previously partitioned in the year 1953 and it was in the share of W. Kumar. W. Kumar expired on or about so and so 1957. And then the suit property was inherited by successor daughters and sons of Munashar Mahato. Munashar Mahato died in his and his daughter Gayatri Devi the one inherited the suit property as because both the plaintiffs and defendants has admitted about the record of right being prepared in the name of Chambu, Pan and others. So I use the certified copy of Khatiyan number 25, plot number so and so, 5 decimals and plot number 353, 23 decimals area, 28, 0.28 acres. Same was orally sold to Gokul Kumar for rupees 50 in the year 1925 itself. This is also admission of the parties. The defendant case is that the same has been partitioned. The genealogy table of Gokul Kumar is also admitted. It is also admitted that the parties that Chandrika Singh is related with Gauri Devi, daughter of Bhaglu Kumar, either related with marriage or with consent. Moreover, this is not the issue before the court to be decided, but both the parties admit that Chandrika Singh is related with Gauri Devi. By admission of defendant number 2, this fact is proved that Gauri Devi and Mani Devi, 2 daughters of the Bhaglu Kumar, are living, whereas his son Munashar Mahato died and plot number 352 and 353 contains 0.5 acres and 0.23 acres here respectively, comprising total area 28 to 0.28 acres. Chandrika Singh did out to in his deposition before the court stated that the land was earlier partitioned and the suit property was given in the share of Bhaglu Kumar. In the statement he has stated that the exact date of partition rather only in the year of 1956 it is written. Before the court he stated in his chief examination that the Batwara deed was given by Bhaglu to Munashar before his death. He himself has stated that Bhaglu died in the year 1957. Further stated that Munashar given this Batwara deed to Gayatri Devi and after execution he said that Gayatri Devi has given it to him. Then he filed it in the court. Subsequently, para-18 and cross-examination, the stated that he has got his said Batwara paper from the box of Minister Kumar in the year 1981. He has had there been any truth in this written statement dated so and so. Witnesses must have stated the date of Batwara because in his admission it was in his possession. Bhakti Devi DT.12.08.2025 has not stated anything that he
Yes, which is that judgment I've got.
Yeah.
There is no finding of fraud. There is no partition.
No partition.
Now, plaintiff certainly had the locus standi to file the suit because he claimed to be the co-owner of the suit property. So there is no doubt on that. So far as B is concerned, whether the suit for declaration of sale deed dated 29/6/1990 as illegal is maintainable in absence of a prayer for partition of joint estate of common ancestor Gokul Kumar and recovery of possession from Chandika. Please tell us, what do you have to say to this?
Because once it has been sold and is residing in a dwelling house, so unless the pre-recovery, dwelling house cannot be partitioned.
Who says dwelling house cannot be partitioned? What is the nature of the property? Where do you say, from where do you say it's a dwelling house, therefore it cannot be partitioned? That is nobody's case. Please don't make out a case from your instructions.
No, that's
Instructions
it has come in the judgment itself.
Where is that finding that it's a dwelling house?
Is page 10, Chandika Singh and Gauri Devi are living in the and other children here earlier Bhaglu was residing in the house and at present Chandika Singh is living.
So that becomes a dwelling house. Dwelling house means what? Is it the ancestral property
Ancestral property.
where it's a dwelling house? Dwelling house is a different concept altogether.
Living-
Merely because somebody is living on the property, that does not become a dwelling house for the purposes of partition. You say that dwelling house is not to be
No,
partitioned.
the partition you must get share in the dwelling house, the house itself, which are constructed and living.
Merely because it's a house, it does not become a dwelling house. Technically, it does not become a dwelling house in terms of the provision of law.
So without recovery of possession,
And without seeking partition.
partition,
He did not claim recovery of possession. He was already in possession.
no, possession. This Chandika Singh is in possession.
Yes.
So
Chandrika Singh is in possession. Who is the
defendant number 2.
defendant number 2 is in possession.
Yes,
He is already in possession.
yes.
So-
Possession from the
So they did not pray for recovery of possession.
no recovery of possession, no partition.
No partition. So recovery of possession, if they have not prayed, then also not necessary that one has to necessarily pray for recovery of possession. ऐसा तो कोई law नहीं.
Partition. Joint
हाँ,
family
partition
to
का प्रेयर करना था. कहाँ है judgment दिखाई? Where is the judgment? That instead of getting a declaration that the sale deed is illegal, he ought to have filed a suit for partition. Please tell us. Transfer property. Then show me something that undivided portion of a joint family property cannot be sold. And in case it is sold, the only remedy of the remaining co-partners or joint family members is to seek partition and not cancellation of sale deed. Then Section 44 पढ़ी है, Transfer of Property Act. (44) and 47.
Transfer to one owner, where one of the two or more owners of the moving property is legally competent in that transfer his share of such property or any interest therein. The transferee acquires as to such share or interest, and so far as it is necessary to give effect to the transferor's right to joint possession or other common or part enjoyment of the property, and to enforce a partition of the same, but subject to the conditions and liabilities affecting at the date of transfer, the share or interest so transferred. Where the transferee of a share of a dwelling house belonging to an undivided family is not a member of the family, nothing in this section shall be deemed to entitle him to joint possession or other common or part enjoyment of the house. Transfer a owner of share in common property, where several owners of moving property transfer the share therein without specifying that the transfer is to take effect on any particular shares of the transferor. The transfer as among the transferor takes effect on such shares equally, where the shares are equal and where they are unequal proportionately to the extent of such share.
You see, section 44 says what? It will be covered by section 44. It is the entire property has been sold, no?
No, entire property, 2 plots.
Only 2 plots. Out of how many?
It does not discuss how many. Section only discusses sale of 2 plots.
The transferee acquires as to such share or interest when 2 or more co-owners of a moving property legally competent in that behalf transfers his share to property or such property and so far as it necessary to give effect to the transfer. The transferor's right to joint possession and other common part or enjoyment of the property and to enforce a partition of the same is subject to the condition and liability affecting the date of its transfer.
In effect, section 44, one corner.
Yes. Yes, please. What do you have to say to this substantial question?
Whether the suit got declaration of said deed dated so and so illegal as is maintainable in the absence of clear the partition of the joint estate of our ancestor Vipul Kumar and recovery of possession from Chandika Singh.
Yes, respondent, what do you have to say?
Year of 2006, my local is there on behalf of Islam number 1 and 2. But subsequently, I found the office because in the year of 2022 also the one wakalatnama is there. But
So your wakalatnama is irrelevant.
that's why
There is a fresh wakalatnama.
yes,
Filed by whom?
22 the office notes.
Para number, order number 22.
Order number 8, dated 2/8/2022.
Order number?
8.
So Arup Kumar Dey is the counsel. His name is not appearing in the list. आ रहा है ना? कोई बात नहीं, नहीं आया तो हम लोग क्या ही कर सकते हैं?
So, why? Because since fresh wakalatnama has been filed.
No, you don't have any responsibility once a fresh wakalatnama is filed. Did you ever file wakalatnama in this case?
Not in 2006, along with one Mahavir Prasad, who was main counsel in this case. In 2006.
This is in 2006.
6.
Right. Correspond number 1 and 2. And where is the fresh wakalatnama? Arup Kumar Dey. Fresh wakalatnama का कहाँ है? Arup Kumar Dey. तो फ्रेश वकालतनामा आया होगा ना कि इधर ही नाम आ रहा है। बताइए कब फाइल हुआ वकालतनामा? उनका कोई वकालतनामा है नहीं रखा। अच्छा आरोप की मांग। एक सेकंड। 16/6/2006 आपका वकालतनामा है 17/7/2006। किसका वकालतनामा होना है? आपका वकालतनामा जो है ना
वो तो पहले का है,
उनका पहले का है,
correspondent से है।
उनका पहले का है,
जी, उसके
आपका
बाद
बाद का है।
लेकिन ये जो
17/7/2006।
but in order book में लोग the year of 2020 तो करे तो वो
इनको जरा इनका वकालतनामा का दर्शन कराइए। जी दिखाइए, 2 फ्लैग लगा हुआ है वकालतनामा। दो सेट वकालतनामा है, कोई नहीं आएगा तो नोबडी आईपीएस लिखा देंगे, इसमें क्या दिक्कत है? वेट थोड़ी करने वाले हैं हम लोग इसके लिए।
नहीं हम तो फिर करेंगे जो अगर वो नहीं है
फिर
तो
मतलब क्या?
नहीं लेते हैं।
आपका नाम अपीयर कर रहा है, आपका वकालतनामा बाद में पड़ा है, आप बोलते फिर करेंगे? कब करेंगे? देखिए सीधा साधा बात है, पार्टीशन प्रूव नहीं हुआ, फ्रॉड भी प्रूव नहीं हुआ, अनडिवाइडेड पोर्शन ऑफ द सूट प्रॉपर्टी को बेचा गया है, राइट? सो द सब्सटेंशियल क्वेश्चन ऑफ लॉ इज whether the suit was, so far as first substantial question of law is concerned, there is no doubt. Now whether the suit for declaration of sale deed dated 29/6/1990 as illegal was maintainable in absence of a prayer for partition. Whether any prayer for partition was required to be made, because there was already a suit, there was already a sale deed in connection with the property. कैसे null and void हो जाएगा? Joint family property का कोई property बिक जाएगा तो null and void हो जाएगा।
Because the first he sold the share what actually the seed possession. That is one of the consideration by the landlord.
Who sold it?
The Gayatri.
There are 2 sale deeds executed by Gayatri Devi.
I'm reading paragraph 6 of paragraph 6.
पढ़िए।
Yes.
यहाँ पे कौन एग्जीक्यूट किया सेल डीड आपका? गायत्री देवी।
Gayatri.
One was sent in Gayatri Devi.
There are 2 sale deeds.
One Abhay Singh that was not challenged. Only my sentence was challenged.
She Abhay Singh's sale deed was prior to your sale deed.
No, just 2-3 months back. After
एक ही दिन काफी होता है।
हाँ?
पास्ट में एक ही दिन बहुत होता है।
हाँ, ठीक है और वाला सेंटर की चैलेंज नहीं की सो
This what of Varanama was prepared during the pendency of the acting.
नहीं that बंटवारानामा तो has been disbelieved by both. So there is no substantial question of law with respect to this. What are the 2 sale deeds which she had exhibited?
my set is dated 29/6/90 and the other set is 13/8/1990. Executed by defendant number 1. Second was in favor of Abhay Singh.
if the Batwara deed is presumed to be genuine, there is only 0.28 acres of suit land. And Magni Devi, Gayatri Devi, Gauri Devi are the legal heirs of Puglu Kumar. So Gayatri Devi had only 0.9 acres of the land.
And she sold below 17, 0.7.
And when did she sell the previous? So far as this sale is concerned, it is Exhibit A. The sale deed involved is Exhibit A.
Exhibit C.
Exhibit C.
Exhibit C तो under partition will be.
आपका सेल डीड का नंबर बताइए.
That is exhibit 1,
1817. And there is one more sale deed, Exhibit A by 1. This is plot number 353. What is the date of your sale deed? 1817.
Date will be 29/6/90.
29/6/90.
90.
90.
90.
और इसमें कितना बेची है वो? How much?
7.17.
नहीं इनके
17 days.
17 days में. एंड 5 डेसिमल वो इमीडिएटली बाद में बेची है 17 के बाद. बताइए. You tell us that a suit of partition should have been filed. जजमेंट लेके आइए. सेकेंड आप में जजमेंट लेके आइए, लिखाइए.